and welcome to this update stream of the Delphi case. Last time I did all this, we had the Supreme Court hearing. And since then, a crap ton of documents and orders and motions has been filed. So we need to talk about it. So that and more on today's show. Yeah, so that is a bit of what's upcoming. I'm waiting for Mo. She has her stream going on right now. She will join us as soon as she is done. I hope. Oh, yes, she will. Because I'm doing these streams more or less to get everybody over to Mo's channel. Because she covers this case a lot more than I do. And as you all know, I have the Young Thug trial to take care of. So, but once in a while, we need to get updated on the Delphi case. And, well, what has happened since last time? Well, Mr. Allen's lawyers got reinstated as his lawyers, but Judge Gohl did not get disqualified for some reason by the Indiana Supreme Court. So she's still there, and she does not have the mindset to recuse herself, even though she should. To be frank, she should not be in law at all, in my opinion. And hello, everybody. Hello, Shelbal, Fedorevsky, Wendy, Bree, Christine, Trinton, and everybody else. And hello, folks over at Rumble. Yay! But one of the first things let's see. One of the first things they tried to do, Mr. Allen's lawyers, was to get Mr. Allen transferred from that prison. They went through it all the things he has been subjected to, and they want him transferred to a jail or a prison closer to Delphi, so they can have actual meetings with their clients. Hello, Art of Deductions. Hello, Fedorevsky. Hello, Bree. Hey, and Anne can ask. Hello. So they tried, and the state of Indiana made a reply. So let's check that out. Share screen. I hope this is the correct one. Yes. Dun, dun, dun. And add the stage. Let's try to, can I do that? Nope. Ugh. Why can't I make this big? Hold on. Darn it. Hold on. I have it here. Yeah, let's do it this way instead. Why can't I make it bigger? Why can't... Don't clip that. Why can't I make it bigger? I don't know why I can't make it bigger. This is infuriating. Yeah, I guess I have to read it. Sorry, I don't know why that doesn't work. State's response to defense motion for transfer. Now comes. They keep making promises. I should be able to. Hold on. Bum, bum, bum. Art of deduction. Want the link to that old one? If you have it, I would much appreciate it. Stop screen. Sorry, folks. Trying to make it work here. What in the actual F is going on here? Yeah, I'll have to read it. Try pressing F11. No? I try that, but it just says, oh, we are making it bigger, and it doesn't get bigger, and I don't understand why. Yeah, so F11 didn't work. Let's go back. What did it? Let's read. Now comes the state of Indiana by prosecution attorney Nicholas M.C. McClelland and respectfully informs the court that the state has no preference to where the defendant is held pre-trial, but the state believes it is in the best interest of the case as an officer of the court to inform the court of the exaggerations and inaccuracies outlined in defense's third motion to transfer. The state would ask the court to consider the following. The charges were filed against defendant Richard Allen on October 28, 2022. That the Carroll County Sheriff's Department requested that the defendant be transferred to the Indiana Department of Corrections for safekeeping and said request was granted. That the defendant was transferred to Westville Correctional Facility on November 3rd, 2022. That the defense filed an emergency motion to modify the safekeeping order on April 5th, 2023, which was denied. That the defense then filed a motion to reconsider and request for due process hearing on May 3rd, 2023. That a hearing was held, after which the court denied the defense motion to modify the safekeeping order, stating that the allegation advanced by the defense were not supported by the evidence presented, which was complete bullshit. Complete and utter bull crap. The court added that the defendant was being treated more favorable than other inmates housed at the Westville Correctional Facility. I would argue, to kingdom come, that's a lie. That one is the exculpatory evidence, but thank you. I needed that one as well. Thank you for sending it on Twitter. I will come to that as well. The court made a finding that it is reasonable and necessary to house the defendant at Westville Correctional Facility and to ensure the defendant's safety to prevent seriously bodily injury to himself. Again, a complete... Yeah. That the defense then filed a verified motion for immediate transfer of custody, alleging additional mistreatment of the defendant at Westville Correctional Facility. That was, again, the court stated the defense assertion were factually inaccurate and were refuted by the evidence the state provided, therefore denying the motion. Remember, this is at the time the defense tried to show the court that Mr. Allen was guarded by persons with Odinist ties. And Judge Gull, as the complete biased piece of garbage she is, just denied it because she is a biased, complete piece of garbage. That the Department of Corrections then transferred the defendant from Westville Correctional Facility to Wabash Valley Correctional Facility for some odd reason, which is a long way away. A long, long way away. So it is over an hour's drive one way for I think it's almost 2 hours one way. They get there. It takes them a couple of hours to get into the prison. Oh, look at that. K squared. Thank you so much. $100 super chat. Wow. I haven't had one of those in a good while. I don't have a soundboard. I have a bell. Thank you so much. Haven't been able to catch you live in a while. Keep up all your hard work. Your dedication to many important trials are greatly appreciated. Thank you so much. I'm almost speechless. Almost. Thank you so much. You know what? Let's see if we can do one of these. Yeah, we can do one of these. Okay, I need to go get it. I'll be right back. Dun, dun, dun. Where is it? Where is it? Here it is. Boom. Habanero. Shaky, shaky. Dun, dun, dun. Ooh. Whew. Have I had lunch today? Yeah, I have. Whew. Whew. That wakes you up in the morning. Whew. Ooh. Oh. Oh. Hiccups. I wasn't planning on getting that one up until next stream, but hey, why not? Hiding that choice. Sorry. Whew. Salvador Dali, member for 7 months. Thank you. How do you prepare to eat spicy food like that? I don't. I don't. Whew. Whew. Hey, no worries. No worries. Yes, I'm drinking Påskmust. This is a very, very local for Scandinavia. This beats every other soft drink every year on Easter and on Christmas. Okay. Let's get back to the show. Where was I? He was transferred from Westville to Wabash Valley Correctional Facility. That new counsel for the defendants has now filed a third motion to transfer. Yeah, and that was the new counsel who is now replaced by his first counsel. They went there and they immediately came to the same conclusions as the previous lawyers. He is in grave danger because he is more or less surrounded by Odinist guards. So that should tell the prosecutor that he has his head way too far up his own ass and should stop trying to make things harder. Number 12 here, that the state has no opinion where the defendant is housed during the pendency of this case as long as he is kept safe. Bullshit. However, the state believes that it is imperative for the court to have accurate information in order to make its decision, which is lacking from the defense motion to transfer. Mr. McLeland, you're an asshole. That counsel for the defendant referenced the emergency motion to modify safekeeping order filed by prior counsel and how they found the allegation in that motion meritorious. That the motion has already been litigated at length and the court found the allegation outlined in that motion were without merit. Yeah, that is because Judge Gall should not be a judge. She shouldn't handle any cases at all because she is opposed of the law for some reason. Number 15, counsel references a letter written by an inmate, Robert Baston at Westville, stating that the defendant is being mistreated as a fact to be taken as true. Here's the thing. This prosecutor, I can bet good money that he has used prison snitches in trials. So why doesn't he take this specific inmate's story as at least somewhat accurate? Well, it's because he's an ass. Now, prison snitches I don't buy for 5 seconds. But if you, as a prosecutor, uses prison snitches, then this letter should be taken seriously. However, prior counsel subpoenaed this inmate to testify at a hearing, and the inmate refused to leave his cell to attend the hearing. Maybe because he felt threatened. The state has documented Robert Baston's history with the court in prior hearings and findings with the court. The allegations by Robert Baston are not reliable evidence provided as sworn testimony, nor has he been subjected to cross-examination. Again, Mr. McLeland, you ass. If you ever used a prison snitch in your life, you have no credibility in your reply here. That counsel for defendant reasserts that the defendant is being mistreated by guards at Westville who practice Odinism. Again, this issue has been addressed in a previous motion and was found to not have merit, and the motion was denied. Yes, that is because you and Judge Gould are ass. You can both eat ass. Yes, I am not a happy camper. I will probably get demonetized. I don't care because I am a tiny bit upset over this. 18. That the defense make the allegation that the defendant was denied recreational time and showers at Westfield Correctional Facility. That the defendant has never been denied recreational time or showers as... yeah, that's their claim. How the fuck do you know? Oh, we called the prison, and they said he was treated well. At the same time as they had onanists guarding him. So their story is as full of bullshit as yours. That when the defendant was moved from Westfield Correctional Facility to Wabash Valley Correctional Facility, he made statements about committing self-ending. As a precaution, he was examined by mental health professionals, and they determined he should not be given recreational time until they can be sure he would not hurt himself. Once he was off self-ending watch, his recreational time resumed. Here's the thing. He made statement about self-ending. No recordings, no filings. Thank you. Best morning live stream ever. Yeah, I'm off to a nice start. That counsel next complained that the checking process at Wabash Valley Correctional Facility is too burdensome and time-consuming. It took them hours after driving for hours. They spent a good 12 hours getting there, getting inside, having the interview with him in the lockbox, getting out of there, and they only met for him for an hour. That's it, for a 12-hour day. That the state was able to review video footage from counsel's visit with the defendant at Wabash Valley Correctional Facility. Counsel for the defendant arrived at the facility at 12:35 p.m. and were processed to visit with the client by 12:58 p.m. That the wait time was extended on this date due to a power outage at the facility, but in total lasted 23 minutes, not the nearly 1 hour alleged in the pleadings. Here's the thing. In that, hi Mo, thank you for sending people over. I'm cursing and
well, I mean, which one are you? Which is this the state's response to something?
State's response to transfer.
Oh, yeah. Well, yeah, that one makes me want to curse too. So I approve.
Yeah. As they arrived at the facility 12:35 and were processed to visit their client by 12:58. Yeah, that's the first checkpoint. Then it took them an additional 30 minutes to actually get to their client. So, Prosecutor McLeland, you're still an ass.
Well, the fact that he's not only accusing both the first defense of lying, which is, one way or the other, I could kind of see that because they were adversarial. But the handpicked, your favoriteest judge ever who never says no to you, you're gonna attack her handpick ones. And not only that, but an independent investigator, you're gonna call into question that person.
Yeah. I mean, there are too many people saying the same thing, and the prosecutor is referring to, well, the judge already made a decision and found your allegations meritless. Yeah, but that's because Judge Gall should not be a judge, and you, Mr. McLeland, is an ass.
Yeah. They have photographs. They have photographs. They have timestamps. They have, how long it's taking them. The fact uh, uh, voters in taxpayers in Carroll County should be beyond pissed, even if they think Richard Allen is guilty, because they are having to pay for all of these transportation costs
Yeah.
to refund,
Mm,
the Indiana Department of Corrections for housing this man.
mm,
They are having to pay for all of that when Cass County Jail, who allegedly has no space, and apparently they
mm,
don't have. uh, You'd think that, you know, jails are set up to
mm,
have,
mm.
safety populations,
Yeah.
people not do
Yeah.
self-harm. So
Yeah.
it just,
And yeah. And I heard that there is a prison close by,
yeah,
recently newly built, who says we can take him. And no. And
no, it,
it's
this, I'm glad more people are looking at this, because as a layperson, as someone who has fairly strong feelings about this, the fact that other lawyers are looking at this and saying, none of this has ever happened in jurisprudence that I remember,
yeah.
it kind of says, okay, maybe you are not, going full Alex Jones tinfoil hats thinking this
Mm.
is something ridiculous.
Yeah. I mean, everything here just reeks of bias. Um,
Yeah.
and they also say that the facility typically does not allow face-to-face visits, but did accommodate counsel and set up the defendant in a special room seated behind a door that was see-through and that had a slot where documents, papers, and whatever could be passed back and forth. See photographs attached. Oh, is it attached here? No,
I don't
not in this.
know. I can't remember where I saw the photos. It might have been, I need to start actually screenshotting and saving the sites where I found the photos, but it was a solid steel door with a little, like, flap opening.
Yeah, I mean it was a cage with a little tiny where they could slide in small portions of food. That was the actual, and they still had the door into this room creaked open with guards outside who could listen in.
Yeah, it
It's infuriating.
it look, however you feel about Richard Allen,
Yeah,
and the state might have evidence that we don't know about, allegedly,
yeah, they're
but
housing. Yeah, they're
it
housing them there for a reason, and that is both
yeah,
prosecution and the judge does not want Mr. Allen to live to trial to
no.
uncover all of this bullshittery, in my opinion.
I know.
That a surveillance camera was present in the room that records movement only and no audio recording. The only thing that was recorded from the visit is when counsel entered the room and when they left the room. That, to the state's knowledge, any jail that attorneys visit to meet with the clients is video recorded and monitored in some fashion. That is for the protection of the attorney and the defendant. And I've heard from many criminal attorneys, they have never seen anything like it. They can always have a meeting face to face with the defendant because
Yeah,
Mr. Allen is presumed innocent.
yes, but not only that, how are you supposed to have a meaningful conversation with someone who's behind a steel door? You have to stay 6 feet away from them. You can't, you're supposed to be able to show documents or digital footage evidence, through this little this little
Yeah,
flap.
mm, it's yeah. Uh, that is for the protection of the attorney and the defendant. Bullshit. Yeah. That neither attorney brought a computer with them to provide the defendant with a review of video or audio discovery, even after DOC made accommodations for them to do so.
It it
They couldn't fit, they barely fit documents through that slot. And why would they want to play stuff to him with guards right outside the door, checking in on them?
Yeah, and you have William Labrato, who goes from being very skeptical of this whole thing.
Yeah.
Uh, New Defense and OG Defense were not bestest of friends. They didn't get together and have, sleepovers and braid each other's hair. New Defense
Mm,
basically was like, all of this is BS until
yeah.
they actually experienced it.
Yeah. And remember, one of these attorneys, it works in Judge Gall's jurisdiction. He has to face
Both of
her.
them.
Yeah, both of them. They have to face her from a day-to-day basis once this case is over. Hopefully, she's getting kicked out before then, but I very much doubt it. Sadly.
Sadly, the state Supreme Court seems to feel like have abdicated their responsibilities to make sure judges are actually behaving within
Mm.
professional standards.
Yeah, and they are in the misconception that, of course, judges needs more protection. But here's the thing: no, not the judges. The position of judge needs protection,
Yeah.
sometimes from the judges. I mean, you had that judge who texted 500 texts. She resigned before ever a hearing. She was smart enough to see the writing on the wall and said, bye bye, going to another career. And this judge, yeah. Next page. That defense were told by legal counsel for the DOC that if they needed anything additional to meet with their client, just ask, and accommodation would be made for them. At what point? I mean, and what accommodations? I mean, they are still not being able to meet face to face with their clients. They can barely shove in papers for him to sign and look at.
And the door is open. If what Randall from Recess said was true, then no one should need to have the door ajar with this man behind a steel door for safety reasons if we have already video, feed going on.
Yeah.
I mean, unless Richard Allen suddenly becomes, MacGyver
Mm.
and, kept a bobby pin somewhere on his person, none of this makes sense.
Yeah. That each request that counsel for the defendant have made of Wabash Valley Correctional Facility has been granted. I mean, not each request, only the ones they can accommodate. They have many more requests. For one, meeting with their client face to face without guards listening in. That could be a start.
Yeah. I mean, hell, the guards with the old defense were videotaping the defendant's face and his mouth as they were meeting with him.
Yeah.
In what world has that been allowed?
Yeah.
With a handheld camera.
Yeah. And if somebody in the chat or your viewers over at Rumble, we think he's guilty, that's besides the point. This is about Mr. Allen is presumed innocent and should have more or less unlimited access to his lawyers. They have to drive 2 hours to even see him. It takes them half an hour to get processed in. Then he's behind, a cage.
Yeah,
This is not how it's supposed to be. Because if it happens to Mr. Allen, it will happen to you.
It will happen to you, and here's what kills me about this whole thing in a nutshell. I mean, I'm sure we'll get to it fairly soon, but we have more stories popping up with Odinist links connected
Yeah.
to other crimes. Now, this is the narrative that the mainstream media needs for Orange Man Bad election year.
Mm.
This is, white supreme pizza movements all around the country doing things in the name of being, terrible, bad people. This is all Orange Man's fault.
Yeah.
Why they are not running with this and we don't hear Rachel Maddow bloviating about this every evening is just
Yeah, I mean, all
infuriating.
the right-wing, very Christian people, they should be all over this. And because this seems to be less of a satanic scare. This, I mean, they have the people over in Washington State, whatever bumhole little town it happened in, double homicide, and then, yeah, they also killed a horse in the name of Odin. All of a sudden, yeah, these are not normal. And if you have them in Washington State and in Indiana, they don't leap there. There will be people scattered around.
Yeah. Also, did they think that the horse was maybe a lemon because they saw all
Yeah,
horses were fruit?
yeah,
That's
yeah. Let's have this lemon to. Yeah, Odin likes lemon. I heard, and but I don't understand why this doesn't create headlines. I really know. And I've heard from people who live in that area who says there are a lot of these people who believe, oh, look, a rune. Let me tattoo that in my face. There's more than one of them. I mean, yeah, I yeah, it's infuriating. Let's see here. That the state pulled the record from Wabash Valley Correctional Facility, spoke to legal counsel for the Department of Corrections, and reviewed the video surveillance from Wabash Valley Correctional Facility, and the allegations put forward by the defense are inaccurate. Yeah, yeah, sure. Talk to the people who are responsible. We didn't do anything wrong, and we looked at the video. We don't see anything wrong.
okay, Nicholas, as a lawyer, if you knowingly write an affidavit, put your name on it representing false facts, that's bad, right?
Yeah. If you
So,
knowingly present false facts, you can be disbarred.
okay, so not only is the OG defense saying this, but the
Mm.
new defense is saying this, and a private investigator
Yeah.
was willing to put her name to
Mm.
an affidavit, but they're all lying.
Mm. Yeah.
All right.
Because Judge Gull, I don't know why. I honestly don't know why she is so reluctant. Because all this Odinist stuff was in the state's own discovery.
It is maddening, and then
Mm.
the response to, "We didn't, destroy evidence," which I'm sure we'll get into,
Mm-hmm.
it just and did you see where she's not going to allow any electronic devices, and she
Yeah.
wants the defense to pony up all exhibits they're going to use for the contempt case?
Yeah.
It
She
it
wants the defense to reveal their case for the prosecution in the contempt hearing. And if they don't, she will hold them in contempt. She is actively trying to get them disqualified again. That's my take on it. Because now she was told by the Indiana Supreme Court that she needs to do it. She can only disqualify them as a last remedy. And I assume that is what the route she is going to take.
Now,
Contempt,
the
here's a
issue
fine. Contempt, I will put you in the cell for a couple of days. Okay, you still claim this defense. Now I can disqualify you because now I have followed the directions of the Indiana Supreme Court.
the only problem is that she is going up against David Hennessy and people from the habeas
Yeah.
collective in Indiana. is
I mean,
on the
I
case.
yeah, and
This is
I saw a name in the habeas because the man who wrote that briefing or motion or whatever it's called, he trains judges in habeas corpus. In habeas, he is he is one of these silent people you never hear of, and all of a sudden he steps out of the shadow for this case. That should tell everyone.
it,
Oh,
yeah, this is going to become a Supreme Court case is what I have a feeling that this is going to be taught in law schools about and and at the bottom of this, these girls are never going to get justice. The government's going to investigate themselves and find nothing wrong,
mm,
but this will be taught in schools. Like this is what happens when you have a rogue judiciary.
yeah. At least I hope so.
I
There's no
I
guarantees of a Supreme Court,
probably not.
but if the habeas collective is in on it, there's a slightly better chance that it will go to a federal level. Because Mr. Allen's constitutional rights are clearly violated, in my opinion. And here they claim that the defendant has a tablet in his cell that he can communicate with his counsel at any time and has had said tablet since he has been there. A tablet that more or less doesn't work because he doesn't have a power outlet in his cell and he doesn't get it charged. That in addition, since the motion has been filed by the defense, the DOC has set up video conferencing so that defendants can now meet with his counsel via video. Not the same as meeting face to face, because video, if Department of Corrections set it up, that means they can record it. That the defendant has commissary in his cell where other inmates do not. Well, that might be because he's not a prisoner. He should have these and more because he should be in a jail, not a prison. That the defendant is being treated far better than any other inmate in the DOC, that should tell you more how the others are treated.
So wait, this having to be shackled like this,
Yeah.
full Hannibal Lecter shackles to go see your lawyers when you have lost a significant amount of weight. And you have to have your hands like this the entire time. So even if you were given papers to read, I mean, you wouldn't be able to read them. You wouldn't be able to manipulate a tablet, really. Your lawyers would basically have to hand it to you. And when they asked if he could be unshackled, no, he's a danger risk.
That the state also spoke to Sheriff Dan Mahor, Mahorr, Mahor from Adams County, and he is not willing to accept the defendant into his facility. He does not have the sufficient space or accommodation to house the defendant. The Adams County Jail also does not have the mental health professionals available to address the defendant's mental health needs. Yeah, but now you have that other prison who says we can. That the state spoke to Sheriff Troy Hirschberger from Allen County, and he is willing to accept the defendant in his facility, but only at the expense of Carroll County. However, the Allen County Jail is currently overcrowded, and Sheriff Hirschberger would have to make special accommodation to house the defendant. In addition, the Allen County Jail does not have face-to-face visits. All visits are done via video, including attorney. Seriously, why does this not sound all the alarms about how presumed innocent people are treated in the great state of Indiana? Remember, these are people who will have a 1-year sentence, a 2-year sentence, a 5-year sentence. Exactly what shape do you want these people in when they get out? Exactly how angry people do you want to have released from prison. I don't get it. I understand punishment, but rehabilitate, especially unless it's a life sentence, people need rehabilitation to function as a somewhat normally in the general population. And here
Yes.
we read how they are treated, and maybe it's no wonder people become reoffenders because they come out angrier than they went in as.
It's not shocking, uh, but it also seems like we're playing very fast and loose with what's going on in other facilities, because I guarantee you that defense attorneys would have made a stink about this. In
Yeah.
fact, the appellate attorney, Kara, Winicky, that I interviewed, I mean, the scuttlebutt is that no defense attorney has ever had to deal with this kind of crap. I mean, this is unheard of in circles, and she's been practicing for, not an insignificant amount of time.
Yeah. So the assertions from Mr. McLeland, ass, I don't believe him for a second. That again, the state has no opinion on where the defendant should be housed awaiting trial. Bullshit. But the state
I was
does
about to
take
say, you
offense.
have spent 5 pages explaining all of your opinions.
Yeah.
I hate when people are like, "Look, I don't have a dog in this fight," then go on to tell you, exactly how they have a dog in this fight.
Mm.
Can we get him for perjury?
Yeah.
'Cause
Defense, blah 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 blah. But once again, filing a motion with this court that is full of inaccuracies and allegations not supported by sufficient evidence in order to influence this court to move the defendant. Okay, here's in here, full of inaccuracies and allegations not supported by sufficient evidence in order to influence this court. Yeah, that's because they know Judge Gull
doesn't care.
doesn't care. That the state has no objections to the defendant being moved to a facility within the Department of Corrections, but the court has already addressed that issue in a previous orders. That the defense is consuming the limited resources of this office. Mr. McLeland, are they the ones depleting
Well,
your
he has to
resources?
respond back like a ridiculous 14-year-old.
This office and this court with repetitive motions that lack any factual basis. 2 sets of lawyers and an investigator. One set of hand-picked lawyers who honestly did not believe in Mr. Allen.
No.
Within days of believing, this is bullcrap.
Yeah, it's very hard to contend that 2 handpicked, one, is a friend of Judge Gull, and the other one has made public statements about ballistics being great evidence. Both of them are like, "This has never happened in our life." And this is I do believe they said a combined 50 years of experience. They'd never had to go through this.
Yeah. And then we have loads and loads of interesting, but let's see here. Yeah, let's go right into the destruction of evidence. Because everything else is on Mo's channel. And this is just me promoting Mo's channel. So you can get over to her channel and listen and read everything, because I have a slightly bigger channel than she has, and hopefully I can get you all over there.
That would be nice. I actually have someone helping me because I suck out loud at using digital graphics.
Mm,
Helping me, I want to marry all the disparate timelines. So you have the timeline of the sheriff's election, you
mm,
have the timeline of the federal lawsuit claiming shenanigans. Then when the girls were found, when Holder and Westfall were, interviewed, when they figured out that those weren't actually interviewed or weren't actually recorded. So I'm trying to get all of the things together so that there's one cohesive timeline, because I think
mm.
that will maybe show a little bit more that not everything can be a coincidence.
Yeah. And here we have, because the state's response, for frick's sake.
I demand he makes all of his responses in Comic Sans because that's how I feel of him.
Mm. I mean, I try to make it full screen, and then I try to, but it doesn't happen. So,
It,
yeah.
it's
Yeah, I don't know why I can't, but let's see. That's still a bit there. State's response to defendant's motion to dismiss for destroying exculpatory evidence. Now comes the state of Indiana. Yeah. By prosecuting attorney Nicholas Asshole McClelland, and respectfully objects to the defendant. No, you don't respectfully object to the defendant's motion to dismiss for destroying exculpatory evidence. The evidence in question is not exculpatory evidence, nor is it potentially useful evidence. Prove it. Show
how
the
do you
interviews,
know?
Mr. Asshole McClelland. Prove it. Show. I mean,
You thought it was, inculpatory enough to sign out a warrant, which you never used for
yeah,
both men's cell phone. So how is it not exculpatory?
yeah. The interviews of Patrick Westphal and Brad Holder are not evidence at all related to this case. Seriously? Mr. Ass McClelland? If they were interviewed as persons of interest in this case, and now you claim they're not evidence at all related to this case. They are simply interviews that the defense wished to use to support a wild theory of this case that has no evidentiary support whatsoever.
Neither does their case. So far, what they have that we have been able to see through their probable cause affidavit, which was riddled with
Mm,
inaccuracies,
mm.
is an unspent bullet
Yeah.
casing.
And did you hear about that unspent bullet?
They
It
don't
wasn't
have a chain of
found.
custody.
They don't have a chain of custody, and it wasn't found in the original search. So they had this crime scene sealed off for 3 days. Then they released it, and then it was released for a full day. Then it was resecured, and then they found that spent bullet. I mean, seriously? So it wasn't found when they actually were there with the bodies. It wasn't found between them. It wasn't that we know of. I mean, nothing of that. And I would assume once the coroner has taken control of the deceased, you go through every square inch to collect evidence. For 3 days, finding nothing, you release the crime scene, and then you resecure it, and boom, there it is.
And why would okay, assuming what you used to subdue 2 girls as a single person was a weapon, was a firearm.
Yeah,
But
and
why
I don't have the
it
document for the spent bullet, but
oh,
I listened to what are they called?
is it Defense
No,
Diaries?
no, it was on Court TV or Law and
Oh,
Seaward,
okay, I'll
one
have
of
to
their
look at that.
episodes. Yeah.
Of th I just
Mm. So,
why would you even think a bullet would be linked to this case? Now, it makes sense to those of us in the public that had no idea how the girls were unalived for several years to think, "Oh, well, they must have been shot." But if their theory of the case is that he used the force multiplier to subdue them,
mm,
not a single person can't do this. It's stupid on its
yeah, the reason for the reason we don't know. Here's the thing: Mr. Holder was interviewed on the 17th. The crime scene was released on the 18th. Then, on the 19th, it was resecured the same day as the interview of Mr. Westfall. And then it was found. And then on the 20th of February, all interviews was by a program error was overwritten and hasn't been able. I think the wordings were some of the sort. Several attempts have been made, but we cannot retrieve it. Okay, how about handing it over to the defense? And that
how about
actually,
explaining how you have people claiming they were there, they spit on one of the girls, but they totally weren't, the unalivers.
yeah,
Explain to me how there's no DNA evidence of Richard Allen. Did you test one of the girls to see if she'd been spat on, that she had any
mm,
foreign DNA? Or was that something you just decided not to test because it would go against,
mm,
whatever?
yeah.
Eh
And however, even though the interviews were not evidence, go fuck you. They were not destroyed by the state purposefully or in bad faith. No,
Okay,
sure,
so, Nicholas, I do have a question.
yeah,
Say they totally fat-fingered, like, "Crap, I accidentally destroyed this." This is still destruction of possible exculpatory evidence.
yep.
Regardless of good faith or bad faith,
Mm.
it still would be a grounds for dropping this trial, would it not?
It can
Regardless of
be.
the faith,
It can be
sort of
depending. It's on the judge discretion.
oh, well, then never mind.
Yeah, and it's all for some reason. If you cannot show bad faith on the prosecution, they cannot be. They have immunity or something of the sort. I don't know the local rules, but imagine if. Here's the thing: if a defendant has a phone, let's take Becky Hill.
Yeah.
And her factory resetting of 572 phones. That will be used against her
Yeah.
as a conscience of guilt. But when the state fucks up, you have to prove bad faith. And here's the thing with Miss Becky Hill. When you return your phone, this is in the private sector, when you return your phone to whoever handles it, they will factory reset it. Did it happen in Miss Becky's case? I don't care. But it shows the difference between the prosecution, between the state and the defense, even though, in my opinion, the same rules should apply to all. Okay, here are the reasons. That on August 10th, 2017, remember that date, Carroll County Prosecutor's Office investigator Steve Mullin discovered that the DVR at the Delphi Police Department for the interview room had been recording continuously for an unknown number of days. Mullin determined that the data storage of the 6 terabyte drive had been consumed, causing the equipment to record over previous recordings, resulting in lost data. 6 terabytes of space is an enormous amount. And
Yeah.
if they pressed start on the 17th on Mr. Holden's interview, they could, unless this is in 2017, 4K wasn't a thing. They barely have 720. I would assume it's been recorded in 480 at best. You could have weeks. But here's the thing. August 10th, he claims he discovered. That means I don't know.
Weren't they past the first discovery deadline?
Yep.
At this time, and
Yep.
it's convenient that all recordings prior to February 20th, because I think Westfall's interview was on the 19th. It's amazing that it was just up until then that we're lost.
Yeah.
I don't assume they're clearing out Carroll County Prison because the rest of the interviews were lost.
Nope. Mullin, blah, 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 causing the equipment to record. Investigator Mullins called the company who installed the DVRs immediately in an attempt to recover the information. The representative advised that all recordings prior to February 20th, 2017 were lost. Advised. That is not, we handed it over, try to retrieve. That is just, it's been recorded over. And they're lost. 2, that on February 17th, 2017, investigators interviewed Brad Holder at the Delphi Police Department. This recorded interview was lost due to the DVR recordings over as described in paragraph 1. The narrative summary prepared by investigators from that interview have been provided to the defense. Here's the thing. The narrative summary is not evidence.
Well, and it states clearly on the summary that this is not to be a verbatim resuscitation of what was said. Please look at the recording.
Yeah. And how... I don't understand, because when you go in for an interview, even if it's recorded to a hard drive, you save a copy, put it in an envelope, because that is evidence. But these absolute incompetent people...
Well, and why did it take them until August to figure out that these were missing?
Yeah, because if everything is stored on a 7 terabyte disk of sorts, then you are mixing different investigations. Because if you're having interviews all the time, that means, okay, we have to go through it all to a copy from that disk. No, you save a copy. I mean, yeah, I agree. Buffoons. Especially interrogation video, which has little movement, therefore compresses at an insane level. I agree. Totally a Russian bot. Let's go. I agree. Yeah, 486 terabyte. You're talking years at that point. Yeah. I mean, 6 terabyte, even today, is an insane amount. I mean, I have a 2 terabyte disk that I save all my streams on. Let me see here how much of that I have used after a year. Dun, dun, dun. I currently have, out of 2 terabytes, I have 1.2 left. And I'm not recording in 480. I mean, I have... I don't know, months of recorded stuff. And this is between February and August. I don't, yeah. That on February 19th, investigators interviewed Patrick Westphal at his home. Okay. At his home. Why? And a narrative report has been provided to the defense. The report does not indicate that the interview was recorded, and no recording has been located in the state's possession. Why? If a person of interest in a case involving 2 dead girls, you go there and you just take notes? What? That the defense suggests that the state destroyed these recordings? You did. Voluntarily, involuntarily, I don't care. Which they believe to be evidence that is exculpatory in nature, further claiming that the loss of the recordings was negligent or purposeful on the part of the state. A, that the interviews of Brad Holder and Patrick Westphal are neither exculpatory nor are they potentially useful evidence. Prove it, asshole!
Pretty much, yes.
Yeah. It's easy to say when there's nothing to impeach you with. That the state did not destroy any recordings maliciously or in bad faith. No, just by pure incompetence. The due process clause does not impose on the state an undifferentiated and absolute duty to retain and preserve all material that might be of conceivable evidentiary significance in a particular prosecution. Arizona v. Youngblood, 1988. I hope that the defense have a reply to that. Let's see here, Arizona v. Youngblood. And again, this is Indiana, not Arizona. So they didn't actually find an Indiana ruling on this. They had to go to Arizona in 1988 to find it. The judge has no responsibility for out-of-state case law. But this is Judge Gull, so yeah. Okay, it was up to U.S. Supreme Court. This is a swab from a kit to collect samples from the boys' nether regions. And they failed to refrigerate. A trial expert witnesses testified that respondent might have been completely exonerated by timely performance of taste, blah, 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 blah. And the due process clause does not require the state to preserve the samples of male thingies, even though the samples might have been used to respondent. Unless a criminal defendant can show bad faith on the part of the police. Okay, so it's a U.S. Supreme Court case. So, okay. Bum, bum, bum. None of this information was concealed, and the evidence was made available. The police do not have a constitutional duty to perform any particular tests. Yeah, but it doesn't say that it can't be used against them. Yeah, whatever. Supreme Court. That's a bad ruling, in my opinion. The state only has constitutional duty to preserve materially exculpatory evidence and evidence that is potentially useful to the defense. Yeah, and in this case, it's asshole McCulkey, whatever his name is. who decides what is and what isn't, and I don't trust him. And then a 1984 case. The mere possibility that a defense may have been created in the future by a piece of destroyed evidence does not mean that there was apparent exculpatory value at the time police acquired the item. The fact that evidence had an outside significance for the defense is not enough to show a deprivation of the defendant's due process rights, 2004. These are bad rulings, in my opinion. But if it's US Supreme Court, here we are. That the defense is merely speculating, that the interviews that were recorded over with aid the defense. They have to speculate because they were destroyed. Mere speculation is not enough. Yeah, that's very convenient, isn't it? Oh, this speaks against them. Let's not preserve it. Let's destroy it and claim not bad faith.
It does not in any way. Pollyanna me, before I started covering trials, would never think that we would descend into these levels of, I'm going to say shenanigans for wanting to use a worse word. But the more I see some of these rulings, it doesn't make sense. Why does it matter if it was in bad faith or they were just dumb? Incompetence.
Yeah, and here, number 11. The lost recording of Brad Holder was clearly not materially exculpatory. How the frick do you know? Even if it could be described as potentially useful, it certainly was not destroyed intentionally or in bad faith. Yeah, that's a great shield to have. Oh, we didn't mean to. Here's the thing. I honestly think that police and prosecutional incompetence should be held against them.
They should be held to a higher standard. You're potentially taking away someone's freedom. This is why we have chain of evidence. This is why it is such a big thing, because the power of the state, in the way I thought things worked, is that's an awesome responsibility. So you have to make sure that everything is, dotted right and T's are crossed.
Yeah, and here he says, further, both Holder and Westphal are still available to be interviewed and or deposed by the defense. Yeah, but that's why the recordings are so important. So you can distinguish, you said this then, and now you're claiming this. Inconsistencies. And here's the thing, they did re-interview at least Holder.
Yes.
2023. That should have been done immediately after they discovered it was written over.
Yeah, and he can change his entire story. There was, bits and pieces that the defense has already pointed out that are different from what was summarized.
Yeah, he claimed that he had never met his son's girlfriend. In the first, that was in the narrative report. And then in 2023, he changed that to, oh, I barely knew her. I only met her once. That's an inconsistency that should raise red flags. Yeah, and Nicholas Asshole McClelland. Stopping screen for a bit. What am I looking?
And so what I will say is, for this upcoming contempt hearing, it seems like I have never heard of the defense having to disclose discovery. I mean, not being a lawful law lawyer, I've only looked it up on, Google, And they're
Mm,
like, that's generally not a thing, but okay. And they can't have I think it was Hennessy that basically spelled out why they can't really have this contempt hearing within this case. If what she wants to do is hold them criminally liable for contempt, they have to start an entirely different case in criminal court. It cannot be attached to the Richard Allen case,
mm,
as far as I understand through Indiana law.
mm. Yeah, and here we have, let's see, bum, bum, bum. And of course, I cannot make it bigger. Request to allow electronic devices at hearing. Comes now, David R. Hennessy, attorney of record, under a limited appearance, and respectfully request court approval for him to have his laptop and cell phone with him at the hearing on March 18th, 2024. The laptop contains documents and information to be used during the hearing. The cell phone will only be used outside the well if counsel needs to contact someone. It will be turned off at all other times. And that was denied.
Okay, if
Or,
McClellan shows up with a cell phone, I want him arrested.
yeah.
Because guarantee you he's gonna have his cell phone and his laptop. And then the judge is gonna say, "The state needs these for documentation reasons. I
Yeah.
can't deny them,
Yeah.
but it's not biased, they just need them."
Mm.
And he asked me nicely.
Yeah. Mm. Yeah, and then you have the state's objection to defendant's response of discovery. The state, we have complied with the deadline on discovery. And
Are you watching the same case I am? Because no, you haven't. You dropped terabytes, days after you're supposed to. But
yeah,
okay.
the information returned by counsel to the state following the removal contained less than what have been provided, thereby requiring a complete review before it could be forwarded to substitute counsel. I don't. That is him. Oh, we gave them a lot more, but they gave back less. And that is their explanation of when the new discovery came to the reinstated lawyers, it contained more than the previous discovery. No,
Sure.
we gave it all. They handed back less. Believe us, judge, because they are the liars you say they are. Because Mr. McClellan is an ass.
He really is. And what man uses a teal pen? That is my color. Sir, kindly do not use a teal pen. It pisses me off. That's my color, and I don't want you tainting it.
Yeah. This keeps making me infuriated. But yeah.
It's supremely upsetting that we went to the state Supreme Court and they basically abdicated their duty.
Yeah.
Anyone without wanting to protect the dignity of judgeship or whatever it is that the state felt was their reason for not taking this judge completely off of this case.
Yeah.
They abdicated their duty, and
Yeah.
we're seeing this a lot more in Supreme Courts. They're either
Mm.
denying cases that would be, useful and or set, firm guidelines of what the state can do and can't do, but, they're not gonna touch it or, it's too spicy or, they're being forced to take cases. It's
Yeah.
just
I mean, it's infuriating, and well, I shared the link to Mo, so you all can have
yes.
much more information. This
I
was
did
just an
read the
update.
entire Frank's memo.
Yeah, I mean, I'm just here to get people over to Mo because I have, besides my day job, I have the Young Thug case. But yeah,
What are
so
you drinking? Is that a rooster on the front of
no,
that?
yeah, this is
Oh,
a Swedish Easter must, and it's like root beer, but not root beer. It's a very local
ooh.
Swedish thing, and this outsells all other soft drinks around Easter at Christmas.
I wanna say
The
something because it has a cock on it. Who wouldn't buy it? I mean, I wanna buy a six-pack for reasons now, but I'm just saying or a three-pack, however it comes in Sweden, I don't know.
a 12-pack.
Oh, oh, hell, I am going to be on Amazon. Is Mo doing what she's supposed to? No, no, she's trying to find cock, drink from Sweden. Flip that feral. Like, 'cause,
Yeah, yeah. Well, well, I've ordered more books, by the way. This is
ooh,
East of the Sun and West of the Moon, Old Tales from the North. This is what I'm going to be using when I have the time to start reading in stories to my other channel, which is called The Elder Man, where I read
oh,
old Scandinavian stories. But yeah, now you are somewhat updated. Go over there.
yes,
I just put the link out, and
and
yeah.
I am working, with our own Debbie W. She is going to be helping me get all the paperwork together to try to make this big timeline
Mm,
that incorporates kind of everything. So
mm,
not only, when the girls passed away that went missing were found, but adding in, when Westfall and Holder were interviewed, when the federal case against the sheriff was started for kind of election shenanigan. I mean, that case
mm.
was dropped, but there's the second sketch,
Yeah,
has always looked a bit like a peen, so
yeah. I mean, that's the actual sketch, but when you put somebody in front of it, we can do this.
1 second, I am getting a call from Mr. Mo, and he's actually calling
Mm.
back, so it might be something
Oh,
important.
okay. Well, thank you, Mo, for showing up, and thank you all for being here for this. I will have the Young Thug trial stream up in when did I put it? 9 p.m. my time, which would be 3 p.m. US time, and I will have the Wheel of Regrets up for that stream. If you don't know what that is, that's it. And thanks to K Squared, she already bought one. So one,
Ooh.
yeah. So I had a spoonful of habanero sauce.
I still say sardine paste has to be an act of something against the Geneva Convention. I I
That was vile.
Why
It
would you
was,
need sardine paste? I mean, I can understand adding umami flavor, but
yeah,
no.
and it's just ground down sardines in a toothpaste tube, more or less. And I mean, I'm glad they gathered it before, but I'm not so sure they were successful in it. Yeah. Oh, yeah.
I need the story time behind that, here's a sardine. What would happen if we put it in a toothpaste tube? And
Yeah.
someone was like, that is a great idea. We are marketing that.
What we Swedish, we are famous for putting strange. We have soft cheese, flavored soft cheese in those tubes as well.
Well, I could, from the land of spray cheese, I can understand that. It's the ground up fish that I'm like,
You're supposed to have it in stews and stuff like that to add some flavor. I don't want it in my stews because it was. And I actually picked out tiny ground down fish bones from my teeth for like 2 days. I burped up that fucking taste for a week. I feel like I'm Jesus Christ. Yeah, yeah. So if you
oh,
want to
that
see me
is
suffer, welcome back to the Young Thug coverage at 3 p.m. US Eastern, where we cover the Young Thug clusterfuck of a trial, and you can make me suffer by buying one of these slots on the wheel. I have yet to determine the exact cost of one of these slots. Yeah. And all of that will go towards either my studio on wheels or the Matsuri Houston trip in August, which will include
ooh.
going to Houston, be at the event, then take a road trip up to Michigan via Atlanta and Delphi. Because I need to just.
May God have mercy on your soul if you're going through Delphi.
I'm going out. I'm going to take a video of the courthouse, maybe go in there and make myself noticed.
Nicholas, you're going to be the next suspect. They're going to release Richard Allen and be like, we found the dude.
We found him. We found him.
I mean, far
Yeah.
be it from me to talk down on my state, but Nicholas, you're going to show up there looking like Odin himself. I would actually, that would be a great gag if you went in with like an eye patch and in full Odin gear. And you're like, I did not approve any of this bullshit. All of you assholes need to stop this shit. As the Odin, I say no, and I would like to be excused from your conversation.
Oh yeah, we have a caviar on those tubes as well. Yeah, because why not?
Fed, I love your picture. I don't know why, but the man in a blonde wig, it speaks to me.
It kind of looks like one of these Swedish dance band.
Every time I see something at Goodwill, I'm like, that could be a Swedish rock band outfit. That could be deductible on taxes.
Yeah. I might actually show. Did I take a picture of it?
Amazon is crazy in the insanity. So 2 12-packs of this drink will cost $109, but I'll get free delivery.
Let's see.
Amazon, you are insane. I'll just have David smuggle me some home when he next goes to visit people.
Yeah. Let's see if I can show the trip.
Why do you have sardine paste twice? You're setting yourself up for failure.
I needed 20 slots. I had 18,
Oh.
and then I found sardine paste in the grocery store, and I thought, that's a bad idea. Let's do it. And it wasn't a bad idea. It was a worse idea.
It's like, I'll just drink straight vanilla extract, Your Honor.
So this is the road trip I'm planning. It's a 25-hour road trip.
Oh, wow.
Yeah. So if I leave on the 12th, of August after Matsuri, because I kind of need a few hours after Matsuri to recover, and then 5 to 6 hours drive per
Yes.
day, and yeah. But
Yeah, I would.
the budget for just the travel and everything, no, without gas, with the flights, with the rental car, with the hotel room and everything, that's about $4,500 of a budget. So I need a bunch of these wheel of regrets to
I love that.
work
Hey,
to
we're
find.
here to support you and
Yeah.
see you semi-gag.
Hmm? Oh, yeah. All right. Yeah, that was the update, everybody. Thank you all for being here.
Yes.
Hug your family. Unless your family is
Yes.
shit, then fuck them and give your love to the people
Yes.
who deserve it. All right? See
Yes.
you. Bye-bye.
Bye.